There we go. Yeah, we're gonna wait about 30 more seconds. We've got two more committee members. I know one of them was on the road a few minutes ago when I spoke to him, and Representative Thomas is about to come busting through the door. Not there, but in just a minute.
Good.
Okay, by my watch, it is 10:03. So I'd like to call this meeting of the House Study Committee on Annexation and Cityhood to order for September 16th. Welcome, everyone. Thank you all for coming. The last time we held a meeting here at the Capitol was actually over in the Legislative Office Building. We had bad weather then. Today it's just rain. Then we were following up a tropical storm. So thank you again for everybody coming, and wish you all safe travels going home when we're done. Just to get us started off, I'll make a quick introduction. My name is Victor Anderson. I represent District 10 in Northeast Georgia, and we'll start to my far left over here with Chairwoman Oliver, if you mind introducing yourself, and we'll come around the table.
I'm Mary Margaret Oliver, House District 82, which is middle of DeKalb County, including all of the $8 billion Emory constituent. I have parts of Brookhaven, Decatur, Chamblee, and Atlanta, and unincorporated DeKalb.
Representative Brad Thomas, District 21. Thank you. Representative Brad Thomas, District 21, Cherokee County.
I'm Darlene Taylor, District 173 in Southwest Georgia.
Okay, and we have one other member who will be coming in very soon, Representative Rob Leverett from over in the Elberton area. So in the meantime, we'll go ahead and get started. We have today's agenda is kind of a if nothing else, it's a sweep up. We've had two of these meetings so far, looking at the way things should happen, a little bit of experience about the way things do happen. And today we're going to be looking at some other issues regarding annexation and primarily dispute resolution around annexation. We will be having our fourth meeting in a few weeks. Chairwoman Taylor and I will be talking later today to try to firm that date up and get that out, when we will spend an extended period of time discussing cityhood matters jointly with our study committee and the governmental affairs committee, hopefully as a whole. So that will be coming up in a few weeks. Today we'll get right into the agenda, and I'd like to ask our first presenter, and where do we have Blake for?
So Russ Grome, he's going to be via Zoom.
Okay. And that is another thing. We do have some folks who are participating via Zoom today, and a lot of people who are just watching the proceedings. So we'll be mindful of that. And our first presenter will be Russ Grome, Chief Financial Officer of the Georgia Department of Education, via Zoom.
Thank you very much. You guys can hear me. I appreciate the opportunity. I am Russ Grome. I'm the Chief Financial Officer at the Georgia Department of Education. And I'm here to talk about specifically city annexation and its effect on school funding. First off, I'd just like to say that city annexation does not directly change total amount of funding given to local districts. We consider this mainly a local funding issue. But while I say that, it could affect the state quality basic education and what we refer to as QBE and our allocations to the districts if there are students included in the annexation. So a little bit about our the main part of funding that we at the Department of Education send out to local districts, our quality basic education, or QBE, is for fiscal year 21. This is approximately $11.1 billion that we send out to fund about 219 districts, for which about 21 of those are city districts. The state's funding formula, though, is based on what we call full-time equivalent, or FTEs. These are student counts, and what we have is 18 different instructional programs. Cost components are identified for each of these programs, and then weighted to reflect the different costs associated with such. These full-time equivalent students are obtained in our March and October counts from local districts report. The funding for each year is based on a 3-count average. So the last 3 counts that have been submitted would be the basis for their QBE earnings for that year. The counts, what they record is the actual classes that students took in attending 6 segments of each school day. So one student, 6 segments for the school day is 1 FTE. FTE funds are earned based on program weights and program code segments reported in the FTE count. So as you can see, that's where we would see the main, if in a city annexation it included actual students or what we call FTEs, then it would not change the overall QB earnings and what the actual state provides to districts, but it could change where we send the funds, whether we send it to the city or the county. So I would like to say though, city annexation could potentially indirectly affect state funding through things like equalization, local 5 mil share or federal funds, but that determination and any impact on that would have to be looked at a case-by-case basis, because there are many different factors that you'd have to examine, and one of which would be, how it affected the tax digest with the Department of Revenue. So that's all I've got. If there are any questions, I'd feel free to I'll answer.
Thank you very much, Mr. Rome. Do we have any questions from committee members? Okay, thank you again very much for participating this morning.
Yes, sir. Thank you.
All right, next I would like to recognize one of our colleagues, Representative Lee Hawkins, to come up. He brought some representatives from the Hall County school system with him, and I'll either one of the two right there will be fine. That's probably.
I'll just take a second. I want you to sit down because I know that y'all have a busy schedule. I appreciate the committee allowing us to come and speak to y'all. I have with me the superintendent of Hall County Schools, Will Scofield, the chairman, Nate Morris, and Mark Pettit, who's also on the school board. They're going to speak to you about what's happening in Hall County. I, as a father and grandfather of children that have been in the city and county schools, have always been a little bit dismayed that children and parents are moved from school to school without any input and the effects on them. And I think that as Republicans, we tend to focus more, and Democrats tend to focus. Well, Mary Margaret used to practice law in Gainesville, so I've known her for a while. I know her, she's got a good heart. We all, I think I better stop there. But I think we all really try to focus on the people we serve, and especially those children. So I'll stop and let them address the committee. Thank you.
Appreciate y'all having us down. My name's Will Scofield. I've been superintendent of the Hall County School. I've been superintendent of the Hall County School District for 16 years now. Prior to that, I was actually superintendent of the Social Circle City District for 4 years, and I was superintendent in Bozeman, Montana for 2 years. So I've stood on both sides of this fence. One of the issues that often gets lost in annexation, and it gets lost because there's so few communities that are affected by this in terms of their school district, is the 1976 rewrite of the Georgia Constitution. I think there was one individual that was part of that at the time that actually knew what was happening, and his name was Tom Murphy, who is the 3rd longest serving Speaker of the House in the United States of America and began his run in 1973. But one of the things that was in that 1976 rewrite of the Constitution was that when a municipality unilaterally annexes property, the school district, if there is a city school district within that annexation, the borders and the tax funds from that annexation follow the annexation of the city. Having lived in Social Circle and watched that from one side, that being the city that was annexing, now living in Hall County and watching it from the other side, let me tell you how that plays out. And it's about 2/3 of the way down your cheat sheet that I handed you, because it's the #1 issue for me. We're all interested in funding, but at the end of the day, I'm much more interested in boys and girls. I have families that wake up and read in the newspaper that their school district was changed last night. I heard that one of you is from Elberton. Can you imagine some of your constituents waking up and being told, oh, by the way, you now need to go to school in Oglethorpe County? We would find that unfathomable, but that is what is written in the 1976 Constitution. I've watched it time after time after time. We are blessed in the Hall County School District to actually have two city districts within our borders. One whose school buildings are in Gwinnett County, that's Beaufort City Schools. And then of course, Gainesville City Schools, which is in the center. And I've just provided you some information there. If you added the number of students in Hall County up, public school students, they're 35,350. We have about 76% of those kids. Beaufort has about 2% of those kids, and Gainesville has about 22% of those kids. So again, we are not part of the process, and we are told on at least a quarterly basis, sometimes a monthly basis, changes that Beaufort is making in terms of annexations decisions, changes that Gainesville is making. And if you added up those changes of annexed properties over the last decade, the net change to the tax collections that we had in Hall County were minus $570,000. You say, well, Will, you're a big district, $570,000 isn't much money. That was 1 year. That was 10 years annexations. Keep in mind, annexations have gone on for 50 years, and annexations will go on next year and the next year and the next year. Let me also just suggest that city districts, for the most part, are not strapped for cash. I don't know if any of you have ever visited the Beaufort City facilities. All of Beaufort City's facilities are absolutely state of the art, and I'm so proud for those boys and girls. Good for them. Gainesville City has 6 new elementary schools, 1 new middle school, and a high school that they're currently putting about another $50 million in. In the Hall County School District, with nearly 4 million square foot of instructional space, we have buildings that were built in the 1950s. My vice chairman, Mr. Nath Morris, his children and mine go to a high school that was built in 1957. My children come home and say, I'm not using the bathrooms. Those bathrooms are so nasty and they're so old, I don't even want to go in those bathrooms. Now, the state of a bathroom does not determine the quality of education, but something to me doesn't feel right when we are just skimming off money from county school districts on a regular basis, sending it to city school districts, and you have that kind of an equity going on in something as foundational as facilities. Let me read you a recent comment that was in the Gainesville City, it was in the Gainesville Times by Chairman Philip Beard, who's not only the chairman of the Beaufort School District, but he's also chairman of the City Council. Chairman Philip Beard said during the August meeting, this is last month, Beaufort had to consider its schools in this development, and they had the benefit of not adding, this is the annexation. It had the benefit of not adding any students while contributing to Beaufort School District Tax Digest. You just heard Mr. Rohn say that state funding is pretty well set. It's based on the kids who show up for school. Let me tell you what's not set. When all of a sudden students go to a different district than they went to last year, the money follows the student. And if you are a county district that has city municipalities that are annexing and have a city school district, so do those dollars. So what a great deal for the chairman of a school board to be able to say, we can pick up another $200,000 a year of tax proceeds, and we don't pick up any students. That sounds great if you live in Beaufort. I'm a dad way before I'm a superintendent. It doesn't sound very good to me as a Hall County dad. He went on to say, Beaufort is not a small town, and it takes a lot to operate our schools and keep the quality that we have. He is, again, the chairman of the Board of Education and the City Council. Finally, at the end of the day, I would suggest that your county school districts in this state are fiscally responsible. And I think that's a Democratic goal, and that ought to be a Republican goal. We ought to do things as fiscally conservatively and imprudently as we can. And you can see there that the Hall County schools, compared to Mr. Rohn's own data from 2020, had a per pupil expenditure of $8,505. The Beaufort City Schools, which needs more money to take care of their students, was operating with $9,621 per student. If we had that kind of money, that would give us another $20 million in Hall County. And I'll just be real honest with you. I'm not real sure what we'd do with another $20 million other than pay teachers a lot more than we're paying them today. So I'll be glad to answer any questions that you might have, but there are some unintended consequences of annexations that deeply affect county school districts that have city schools within their borders. And quite honestly, Just the idea that someone can make a unilateral annexation district and change a child's attendance boundaries where they have to register for school tomorrow, that doesn't sound like a conservative or a liberal or an American ideal. Be glad to answer any questions.
Okay, Chairman Hawkins.
Thank you very much
Oh,
for
you're
coming. I appreciate it very much. I have 2 independent school districts in my house district. City of Decatur spends over 15,000 per child. You have worked out, if I'm right, tell me if I'm right, some independent agreements about where the children would go to school. And in Decatur, they've done something similar. They've given some choice to families about where the child goes to school after an annexation. Have you been successful in those local agreements trying to help parents make decisions?
Mr. Morris and I don't know, Nathan, what is it, 15 years ago, came up with an agreement with Gainesville City that we said, you know what makes sense? Let the cities do what they want to, but let's let the kids stay where they want to stay and just leave the tax money where it is. That worked out tremendously well for 10 years until some members of the Gainesville City Board of Education decided, now, wait a minute, we'll let you keep the kids, but we want the money.
Mhm.
And we said that just is that there's no way we can look our constituents in the eye and do that. So our agreement ran out about 2 years ago,
Mhm.
and we no longer have that agreement. But that's what ought to happen. If municipalities annex a city, it should not change attendance boundaries of school districts, and it should not move funds from one district to another.
That's been the subject of our local legislation. So y'all have not considered going back to have local legislation to kind of reconstruct that deal.
Again, this is in the Georgia Constitution. It would actually require a constitutional amendment. Believe me, we've had a number of meetings about this, a number of questions, and unless both parties agreed to it, it would have to be an actual change in the Constitution.
Mr. Chairman, there's a dispute about the constitutionality of that provision, and the city of Atlanta always asserts that, but they never show me the documents.
Right.
So I think that's one of the issues that is troubling in this area, is that assertion that there's a constitutional amendment. And I frankly don't think I can be authoritative on that issue.
Okay, I think we have some input on that from our legislative counsel, Stuart.
Sure.
What
and,
number, Stu?
What number is that?
Yeah, in 1981, the Supreme Court, Georgia Supreme Court in the Upson County versus Thomaston case held that, and I'm just going to read it right here. We hold that absent an expression of legislative intent clearly to the contrary or a valid agreement between the school systems involved, municipal annexation extends the limits of an independent public school system operated by the municipality. So that would appear that the Supreme Court is leaving the door open to either legislative action or agreement between the two school systems to address the matter of extending the boundaries of an independent school system following an annexation.
May I ask one other question? Do you think it's settled law, Mr. Morelli or Mr. Scofield, that if the city of Atlanta were to go 100 yards further and take the Druid Hills High School from DeKalb County, that they would acquire that $100 million asset?
That's not a matter I've looked at anytime recently. I do know that there is a much older Supreme Court case from like 1918 that would seem to, as long as that case hasn't been overridden, which I don't think it has, or the statute hasn't been addressed, or matter hasn't been addressed statutorily, then probably the property of the school system, the property would fall under the control of the annexing city school system.
We actually have 6 schools that are virtually islands that over the years, as the city of Gainesville has annexed, they've annexed right around our schools. Imagine how this is when you're out welcoming car riders and boys and girls in the morning, when you see a Gainesville city bus go right by your school, go into a neighborhood across the street, pick up kids and take them back 7 or 8 miles to the Gainesville city schools. If Abe Lincoln were here today, he'd call this bass-ackwards. It is one of the most incredibly unfortunate pieces of legislation via the Constitution that I've dealt with in my time, 22 years as a superintendent. Mr. Morris, you were going to say something.
Yes, thank you. I'll speak up in response to, we did realize and that there was a possibility for an agreement, an intergovernmental agreement to be made between
city, at the municipality, and the county school system, and had that agreement in place. That was approved by Superintendent Scofield. That went away 2 years ago. Now we also realize that there is potential for legislation, but also want to refer to the State Department's comment. There's 21 city school systems that impacts 21 counties, and there's 4 or 5 that have multiple independent school systems within there. And we also ask the question, or beg the question, that how much emphasis, how much interest is there in the impact of those 21 counties and those 4 districts that are dealt with 2 independent districts.
Is out of our 159. So again, it's pretty hard to drum up a lot of interest from individuals who don't deal with this on a day-by-day basis.
Okay, and if I can step back, Mr. Morris, will you just introduce yourself to everyone? I know Superintendent Scofield kind of did that ahead of time, but if.
I'm Nate Morris, Vice Chair of Hall County.
Gotcha. Okay, thank you very much.
He's actually served for 22 years.
Yeah. Well, thank you. Thank you. And we very much appreciate you guys coming in. Mr. Pettit, did you have anything to add to this discussion also?
Thank you, Mr. Chairman. The only thing I would ask this committee, I appreciate your time and consideration. We just want a seat at the table. When municipalities in our county are annexing unilaterally and almost without check, boards of education are very affected. And we feel at this time that we have no statute or legal backing for a seat at the table in the process. I think a lot of your committee hearings, I've watched the last 2, have focused on dispute resolution between county and city. But school boards, my ask is that school boards have a seat at the table as well. We're dealing with children, education, and quite a bit of funding. And I appreciate your time today.
Okay, thank you very much. And at this time, I'll recognize Chairwoman Taylor for a question.
Thank you. I just have a couple of questions. Do the students have an option to go to which school they want to go? Or is there a transfer, a cost, a fee, anything if you switch?
That's an excellent question, ma'am. And actually that would automatically overnight, they can go to the annexing city school district because that is their home school district. For them to stay in Hall County, we would have to give them permission or they would have to pay tuition. And some people have said, well, it's only a few hundred kids. Why don't you just take them? And the reason we don't take them is because we're charging 2,000 other children tuition to come to our district. And it's awful hard to look into the eyes of those families and say, well, you have to pay tuition, but you don't. So the answer is, if the county district wanted to keep them, they could.
How much is the tuition if someone wants to attend?
$1,000 a year, 900 if they.
Okay, one of my counties that I represent does have a city and a county school system. We're much smaller size. One of the other, so I recognize this is an issue. We don't have the annexation problems that you have had. My big concern though is your conditions of your buildings and your school facilities. If a parent has a choice to sending their child to a better school, how is it that your schools have not been able to keep up? Do you have any new schools? You talked about the age of the high school. What's going to be the best for the kids? And do you have plans to modernize and bring yours up to a better level?
You make my point. We're in the middle of a 10-year facility plan, but historically, our ability to leverage local tax funds to build schools has been minuscule when compared to a Beaufort City or to a Gainesville City. That's the entire point, Madam Chairwoman, is that there are savage inequalities in districts in their ability to raise funds. There was a time when Gainesville City's Digest brought in almost 60% more on a per pupil basis than the Hall counties. It still brings in 25 or 30% more. So we have buildings, and I would say you called it a better school. A better school is not defined by the age of the facility. It's defined by the goals within the school, the leadership within the schools, and the teachers' willingness to work until their fingers bleed to meet the needs of boys and girls. So I would put our district's facilities for their ages up against anybody. I'm just saying, if you've got $6 million in your checking account and I've got 200,000 in mine, there's a good chance you'll live in a nicer house than I do. And that's what we have going on in a lot of these districts like Hall County versus a Beaufort or a Gainesville City.
What's your current millage rate for your tax rate?
16.49.
Thank you.
Thank you very much. Any other questions on the part of the committee? I'd like to introduce Representative Leverett, who had a little ways to drive this morning, got held up in traffic.
Gonna question. How do I activate this thing?
Right there.
Oh, you got it for me. Okay, good. I just, one question. I had always thought that city school systems and independent systems were basically synonymous, or is there a distinction between those terms?
They're actually called independent city school districts. So
Okay.
you're talking about the same.
Same thing. Okay, all right, thank you. Just want to make sure. And you say there are 21 of those statewide?
Mr. Rohn suggested that there are 21 statewide. We've had some consolidations in the last decade. And so if he says 21, it's 21. I would have known it's between 20 and 22. So.
Okay, all right, thank you.
Okay, thank you. Any other questions on the part of the committee?
I just want to belabor this point that's is troubling for us is this, you think there's a constitutional prohibition, but our legislative council and I both think that you can work around that with local constitutional amendments and local legislation. And that's what we in DeKalb and City of Atlanta have been trying to do. So that argument goes on a lot about what are we allowed to do with local special legislation and local constitutional amendments that used to exist that don't exist now, and what can't we do? That's kind of some of our problems around there.
May I address that?
Yes, sir.
And I would agree with you. For 22 years, the legal counsel that we have sought, both from a city district standpoint and now from a county district, has said it is a constitutional issue. If this committee could get the attorney general to say, oh, no, it is not a constitutional issue. It is an issue that could be handled by local or state legislation. That would open up an entirely different avenue to address this issue, because we will not get everybody sitting around the table to agree to this. It will have to be legislation or constitution or both.
Okay, I'll recognize Stuart Morelli, Legislative Council.
Just to point out, actually, the Attorney General in the 40s and the 50s did address this matter, and it was actually the Attorney General's opinions that the Supreme Court based its 1981 decision on, finding that the Attorney General has correctly stated the law. And then they held that the school boards, the annexation by a city moves the school boundary borders to be coterminous unless otherwise stated by the legislature or an agreement.
If you're a real lawyer, you go research constitutional amendments from the 40s and the 50s, and I'm not there. Yeah,
Okay, the committee will maintain etiquette. I'm just. No, this matter is duly noted now, and we will seek clarification through our findings. Once our findings are completed, we'll see if we can't get a little better clarity that somebody like myself, who is not an attorney, maybe can understand too. So, thank you. Thank you very much, gentlemen. Appreciate your contribution. Now I'd like to call Mr. Brad Alexander from a parent with the City Schools of Decatur. Okay. And I asked Mr. Scofield, Superintendent Scofield, he accommodated us very much to speak up to the microphone. As we are a hybrid meeting, there are people, it'd be better up here. The wired mics tend to work better, just to kind of remind everybody, if we can try to do that. That way, those who are viewing the meeting remotely or participating by Zoom can actually hear and participate in what's the discussions going on. So, Mr. Alexander.
Some of y'all have seen me speak as a lobbyist before, probably lots of times, probably more than you wanted to, but I'm here as a dad and a citizen, mainly because I had the bad judgment to volunteer to get involved in trying to settle some annexation issues with DeKalb and the City Schools of Decatur, where both of my children are in elementary and middle school. And really the reason I took an interest in it is I have a couple friends on the school board and noticed a couple things. One, we had a long-running, multi-year, very acrimonious dispute with DeKalb County over the DeKalb County schools over annexation, and it was getting to the point that it was volleys being fired in the press. People felt very strongly about it, and it was really toxic to the ability of those two systems to work together. And they do work together a lot. They share facilities, they share security information. The DeKalb schools provide services to the Decatur schools, such as special education, that they can't provide on their more limited budget. And that dispute was starting to erode that cooperation that we needed to make that successful. The other thing is that we were in the middle of this epidemic, and the school boards desperately needed to be able to focus all of their attention on trying to open schools and get kids back in them. And they're spending hundreds of hours and hundreds of thousands of dollars in both cases, paying lawyers, accountants, consultants, financial analysts to try to figure out this mess. And this is all happening with two systems, neither one of which want to change their boundaries. So the Decatur schools are happy with their boundaries. The DeKalb schools are happy with the status quo. But the fact that even though they're the largest components of everyone's tax bill, there's no mechanism for either of them to agree not to take students and tax base away from each other, which really makes no sense. I mean, people in Decatur move there, pay crazy property taxes purely to get into the school system in most cases. And the biggest thing that composes that tax bill is off the table in annexation. It's addressed only if the city doing the annexation voluntarily wants to address it. And if you think about DeKalb County, there's a couple things that are unique about these two school systems. One is that in Decatur, there's a very small commercial tax base. So if there are any needs to raise more money, it lands almost exclusively on homeowners. If you look at DeKalb, there are large parts of the county with a ton of students and very low property tax valuations. And then there's 3 or 4 big commercial centers that basically allow the DeKalb County schools, which are one of the largest systems in the Southeast, to function. So when you see annexations between those two, it's usually because there's a developer or a large commercial property owner that wants to get into the city for reasons that have nothing to do with the school system. They want to get a zoning thing they can't get out of the county. They want to get a service that they think the city does better. They're getting an incentive of some sort. So those are why those happen. But when you have a shopping center, an office tower, something like that, get pulled out of DeKalb and into the boundaries of the Decatur school system, it makes a major impact on DeKalb's ability to function. And that's probably Marshall or some of the boards here, even more so true with Atlanta annexations, right? Where you have larger swaths of commercial property that would be subject to.
Well, we also have.
Yes, if you don't mind, if you would.
Sorry,
maybe come up to the
disrupting
microphone here.
your procedure.
Or I can go up to that. And I'm Marshall Orson. I'm a member of the DeKalb County School Board, and I was the chair last year, and I've been involved in this annexation issue from its inception. We also have the issue in DeKalb County that some of our highest value residential real estate is literally I live on a street in which if I turn out of my house and go 8 doors down, I'm in the city of Atlanta. And so the vulnerability that DeKalb has both commercial, but also high value residential real estate, which is also true, quite frankly, in the area that's surrounding, at least on the west and north of the city of Decatur.
Briefly, how we tried to tackle this and what the upsides and downsides of that were. We took the opinion following legislative council and attorney general that local legislation was allowed to address this. We talked about doing an intergovernmental agreement. And there were really 2 problems with that. One, intergovernmental agreements exist as long as both sides want them to exist. So as soon as someone gets a big enough incentive to break the agreements generally are broken. So it's not much of a long-term assurance that you're really doing anything. And the problem is if you build a school system around an IGA and then you yank the rug out, you've got often students in one place and money in another place, and neither school systems are able to operate particularly well. You don't need to overfund a system with a small student base, and you don't need to underfund a system with a large student base. The second issue about them is they really lack agility. They tend to be agreements built around kind of one freeze frame moment in time, and circumstances change, they don't evolve, and that then undermines them as well, both in terms of their effectiveness and the desire of both sides to keep them. So after, gosh, probably 40 or 50 hours of discussion, including mediation, including a lot of lawyers offering a lot of opinions, we decided that local legislation was a path forward. We crafted this bill that attempts to address everything that we think might happen in an annexation. And generally the effort it makes, and it's sort of a blunt instrument because you don't know what the tax rolls are going to look like 20 years from now, is to keep the DeKalb County tax rolls fiscally stable by permanently leaving some money there, but leaving room for some money to follow students to Decatur if large numbers of students are pulled into Decatur. We think that it will work. I don't think any of us think that it's a perfect solution. There are many things that we felt like on both sides were imperfect about it. The good news is that process enabled the two school systems to get back to a point where there was a high level of cooperation, a lot more alignment on trying to serve the kids that are really embedded in both school systems. So I think it was good, significant progress, and it created a framework for how you might do that. I would just add too, there's no reason you can't adapt a lot of what that local bill did into general law. We put a lot of time into trying to figure out how those moving parts work and how to handle things like facilities, when to give students choice in what schools they attend and when to compel them to go to a school, how to divide up tax base, and also created an ongoing sort of cooperation committee. I think we gave it a better name than that, but it's a group of appointees from both school systems that work together over time to specifically for the purpose of making sure that as this agreement moves money between the school systems, that it also moves services between the school systems that can optimally help both sets of students. So it's a good roadmap, but the bottom line is what we're doing now really doesn't make any sense. We've got an annexation system that was built around the notion that when you annex, you don't really affect schools because they're constrained within county boundaries. And then we've got these 21 exceptions where really the biggest impact of the annexation is felt in a party that has no voice in the process. So I think in an optimal world, there really should be notice at a minimum. There's not even a legal requirement that a city tell a school system when it's going to annex. That's worked pretty well in Decatur recently, but I don't know how much. I doubt the DeKalb County Board feels like they're getting a lot of notice on that stuff. And there really ought to be some kind of standing for city systems to have an opinion about this and make sure that voters know what that opinion is. And I would just add one more thing that can put an added wrinkle in it when you think about annexations in urban areas is we have these things called development authorities that can do bond for title transactions and abate taxes, which are often great. And I know a lot of rural communities have been very effective at using those kinds of structures to pull employers into their boundaries that otherwise wouldn't show up. But because no one really wants to pay taxes, and let's say you're a large commercial developer, you're going to put a project in next to a city boundary, you're going to go make an effort, because why not, to talk to that city and see if you can get your taxes abated as part of the annexation. So that compounds this problem because the county schools lose the taxes through a process they can't control. And then when the students from the annexed area come into the city schools, no taxes come with them, or vastly minimized taxes come with them. And I know you're not dealing with bond title structures and development authorities in this, but I did just want to underscore this. That's another wrinkle that we really see mostly in Metro Atlanta. I think I haven't heard a lot of cases of that outside of 285, but it's been a concern here.
Okay, thank you, Mr. Alexander. Do we have
Thank
some
you.
questions?
I just want to thank you for your
I think
hundreds of hours of volunteer efforts on this.
it's a fun Rubik's Cube, and thank you too. It's not the kind of problem that often gets solved here, and it was fun to fix it. Thank you.
Okay, any other questions on the public committee? Oh, excuse me, Mr. Alexander, if we could.
I'm disrespecting the committee by stopping out.
That's perfectly fine. We're used to it.
It was not intentional. I'm, after all, a lobbyist. It's sort of you think I'd know better.
We have that effect on most people.
Yeah.
That's fine. I'm Rob Leverett. I just had a question. You mentioned some local legislation. Was that legislation actually passed?
It was passed on day 40 of last year. It was sort of a photo finish thing where we worked all session on it and thought it was going to fall apart, and finally got a deal on like day 38. And I think we broke some pins in the legislative council office trying to jam that together. I'm sorry if whoever we victimized on that, but yeah, we got it done. I think it's about 80% good. And I really would urge y'all to look at that and see if there's a way to adapt some of those components into general law, because that's really where it belongs.
Do you know the bill number? Okay.
Yeah, Blake will get us copies.
We've got
of all
about
those.
45 previous drafts too, if you really want to.
I don't know if I've got the time, but thank you for your kind offer.
Sure.
Thank you. That was all the questions I had. Thank you, sir. Thank you, Mr. Chairman.
Okay, thank you, sir.
Thank you.
All right, next I'd like to call to the microphone Mr. Ed Lindsay from DeKalb County School System, lobbyist for DeKalb County Schools.
Good morning, Mr. Chairman, members of the committee. I was on the other side of this discussion and was very pleased that the two school boards working together, in particular, the chairman of the two school boards working together, as well as with Brad and with my team at Denton's, were able to finally reach an agreement. This was actually a 3-year process that we went through. And so we got all the way to day 40 on the 3rd year as we tried to work out an agreement. And I do take sharp exception to Brad. He did not devote 40 to 50 hours. He devoted probably closer to 200 or 300 hours of his efforts to that. And I do very much appreciate it. A lot of what I want to discuss has been discussed. I just want to reemphasize a couple of quick points. The Supreme Court decision that was handed down in 1981, which is the Upson County School District versus City of Thomaston, 1981, made it very clear that while there is a presumption that when a city school, rather when a city municipality annexes property, that the school district lines change, that presumption can be overcome by the legislature or by agreement. That was, and I don't know if I'm still a real lawyer, Mary Margaret, but I did read the 1940s Attorney General decision, thanks to this gentleman over here who helped work with us as well. And so we did work very hard to come up with, actually ended up being 2 different pieces of legislation. Decatur School District and DeKalb County School District were able to come together with an agreement, and we were able to get it passed by agreement. The City of Atlanta School District was not as willing to negotiate with us, so we had to pass a separate piece of legislation dealing with the City of Atlanta School District. The best example I can show you in terms of the danger to school district, to county school districts where where annexation can run amok, is found in the Emory annexation by the City of Atlanta, in which, and correct me if I'm wrong, I may be off by a student or two, but approximately $2.6 million a year worth of revenue was shifted from DeKalb County schools to the City of Atlanta schools in 6 students. Now, I've heard as high, I could be way off, and I apologize, I could be as high as 8 students, but it was somewhere between 6 to 8 students for $2.6 million a year, not 1 year, but a year got shifted. That is simply something that a school district cannot absorb year in and year out, particularly if this sort of issue is not addressed. And it falls squarely within the public policy realm of the General Assembly to do so. I think the courts have spoken very clearly that it's clearly within your purview to take on this very serious issue and to address it. A lot of these schools are located in fast-growing areas, both the local school district and the county. So this is an issue that not only exists for DeKalb County, not only even exists for Hall County, but exists in multiple counties throughout this state. And it is an enormous issue when it comes to making sure that the necessary funds are available to educate the children in these schools take place. And that fortunately with Decatur, we were able to, the parties worked very hard together. While it did take 3 years, it was 3 years of, I believe, while there was some acrimony along the way, most of it was good faith negotiations taking place on both sides, trying to come up with a reasonable solution. Like I said, we had to take a little tougher stand with Atlanta Public Schools, but so be it. I used to represent the City of Atlanta, so I understand. And so anyway, I just want to emphasize that sort of real life situation in which why this is such a desperate issue for the county school districts, where there is a local school system in place that it desperately needs to be addressed. Also want to really briefly sort of touch on something else that Brad mentioned regarding the TADS, which is an enormous problem for the county school districts, for that matter, city school districts, because they don't have a say-so. Not only do they not have a say-so in the TADS, but they're not even given notice of the TADS. A lot of times where DeKalb County, for instance, finds out, not through an official channel, but through an unofficial channel that a TAD is being proposed, they can go in and sort of raise the concerns and objections and take care of it. But there are other times in which they don't even hear about it through the back door. And so as a result, this is kind of not just playing whack-a-mole, and we all played whack-a-mole probably as a kid, at least those of us who are a little bit older, but imagine trying to play whack-a-mole in the dark, which is exactly what the school districts are having to do. When this amount of money is being impacted in terms of revenue for a school district, School districts ought to have a say-so, and at absolute minimum ought to have notice, but really should have a say-so in the final decision. And we would ask that y'all address that as well. Marshall, I have here, you've already heard from Marshall once. Marshall, did I leave anything out?
There are a few things I think that scope of magnitude, again, I started working on this in 2017 when the Emory annexation came into being. And what was interesting is that the original city ordinance, and it was interpreted as a delegation of the legislature's authority down to the city council in terms of their annexation property, had initially disavowed changing the school district for the city of Atlanta. And in fact, on that premise, we didn't mount any real effort to oppose it because the dispute over municipal services from the perspective of the school district was not our issue. At the 11th hour, literally at the 11th hour, the city council inserted that the school districts would change, which ultimately led to us filing a lawsuit and securing an injunction stopping the annexation based on the city having failed to properly follow its own procedure, its legislative process in there. An imperfect solution that then sort of fell by, at the time we thought what was then SB or HB 53 had passed through the legislature unanimously with the support of both houses. And that would have actually addressed the solution because that bill is essentially what the Atlanta bill is now. The other part is the scope, the magnitude of this. Since 2013, DeKalb County has lost, and when I say lost, that is that monies that have been shifted that would have come to DeKalb, but have now shifted to the city of Atlanta, has lost about $25 million in terms of taxable revenue for the city of Atlanta, and another about $5 million to the city of Decatur. So it is, over 8 years, that's over $3.5 million, and those are in perpetuity because that's the outcome and the impact of each annexation that takes on forever. And so to Ed's point, there's a very real impact. And I think it's important to, we spent a lot of time, and I was in the middle of this, quite frankly. The bills we have for land and Decatur are different, and their potential impact is different. And I'm going to try to stay as objective as that, because I think to Will Scofield's comment, there's a question about when students get shifted to, whether they get shifted against their will. The Atlanta bill has in it, basically creates a secondary process for school annexation. It says if you want to go annex because you want your garbage picked up by the city of Atlanta, that's fine. I happen to live on a street. I get to watch the DeKalb and Atlanta trucks run up and down my street. And so I got the worst situation you could have. But if you're going to have a school annexation, it's a separate process. There's a threshold that requires that 2% of the student body from DeKalb County eventually be shifted. And then there's approvals that are built in there that have to be secured. The Decatur bill is different. So the Decatur bill provides that if there's an annexation, those students shift. And the Decatur bill is mostly about trying to protect the commercial revenue. And our board supported the bill, the Decatur bill. I happen to have a slightly different opinion. I want to be fair about this, but we're not here for the debate about that. But it is important to recognize that there are two approaches that are exemplified in the two different bills. And to make state level policy, I think it's going to be important to kind of account for all those factors, because the close in nature of where we are in the metro area may not be apropos to, I think it's Jefferson, which has two systems, and Thomasville, so there are examples. The last thing I want to say, and this has to do with constitutional provisions. So part of it, I think, in the issue between Atlanta and Fulton County had this because there was a local constitutional amendment that seemed to indicate one outcome, and then the state decided that local constitutional amendments were no longer actually allowed, and there was a lot of legacy around that. But from the perspective of a county school district, the state of Georgia has been very clear, and this is with no disrespect, because we have city systems that are doing great jobs, right? And they care about their kids. But it is, as a matter of policy, the state constitution has said that the preferred way to deliver educational services is through county districts. And the way they have said that is by saying we can't have any more city districts in there. So if a city district goes away or merges, it's not like there's a limited number. Now again, no disrespect, but we have this odd situation in which the actions of the cities themselves, not even necessarily the city school districts, can have an adverse effect on these county school districts, which the state of Georgia has voiced is the primary way. Let me take away the word preferred because that may be a little too weighty. The primary way that the state of Georgia has decided that children in Georgia should be educated. And I think that underscores kind of the difficulty and the significance of the problem, because if the county systems, the 159 counties we have, are the preferred or the primary way of educating our children, I think it's important that we not allow external forces that are often beyond even the input of the city school systems to have a negative impact in county districts doing the job that they've been tasked with under the Constitution by the people of Georgia.
Is that in many situations with annexation, it makes sense where a city annexes certain property to also shift the lines for a municipal school district. But in many situations, it's not, and we need to be able to address those, and the school districts can address those. The two different methods that we took with the versus Decatur versus the City of Atlanta School District sort of exemplifies the difference between folks willing to work together and folks who weren't. But we have to recognize that the needs of a city city in terms of annexation may be very different from the needs of the respective school districts. Matter of fact, one of the big discussions that we had with Decatur School District, and Brad articulated it more than once very well, said, guys, y'all are mad at us for what cities does that we didn't have any control over. And he was right. But nevertheless, it had an enormous negative impact on the county school district. And that's why we were so glad to be able to work out a resolution. And the main thing we think we need to have here is make the legislature understand not only what has happened in DeKalb, but also what the problem that exists in other areas as well, and make sure that y'all understand this is clearly a public policy issue for y'all, and we look forward to working with you to help address it. Thank you, Mr. Chairman.
Thank you. Questions? I think Chairwoman Oliver.
Speaking of other areas around Metro Atlanta, let me give you a hypothetical, give you what your best judgment is. If 40% of City of Atlanta's tax base is de-annexed and goes into another city, where do those children go to school, and how do the participants or the citizens of that area know what's going on?
That's a problem that hasn't been worked out by the folks who are supporting that area. I made a pledge that I was going to stay away from that subject because I also represent the organization that opposes it, and I'm going to try to follow that pledge. But to answer your question, that's part of the problem that has not been addressed and has not been even seriously considered or addressed, because right now those students would be left in limbo. I'll leave it at that.
Thank you.
And you can't leave several thousand students.
Yeah, just for guidance purposes for us, the question of the discussed City of Buckhead has that bill has been introduced and assigned to Chairwoman Taylor's Committee Governmental Affairs, and will be addressed through the process that way. So we're trying to stay on focus.
I know that. I look forward to having that discussion on a later day.
Thank you.
But thank you for the question. That needs to be addressed again.
Any other questions on the part of the committee for? Okay. Thank you. Thank you, everybody who participated in our discussions relating to the effect of annexation on school systems. That's a major topic that this committee is considering in our study committee findings here. Now we're going to shift gears just a little bit. I want to ask Mr. Roger Murray to come to the front and talk about public debt impacts of annexation. Roger is with Murray, Barnes and Finister, and thank you. Appreciate you coming.
You're welcome. Glad to be here. I'm going to sit down if you don't mind. Excuse me, and put on my reading glasses. Hey, Rob. I'm doing all right, thanks. Good to see you. All right. As the chair said, my name is Roger Murray. I've been a lawyer for over 32 years, and I represent cities, counties, and school districts and bondholders in connection with public finance matters. In appearing before you all today, I just want to underscore and emphasize the fact that unlike the previous speakers and many of the speakers that are going to follow me, I don't represent anybody. And in fact, I've represented each of the constituents, if you will, that you guys are concerned about. So I don't have any agenda. I'm not representing my firm. I'm just telling you, sort of shooting from the hip and telling you what I think as a lawyer who practices in this area and as a, as a resident of the city of Atlanta. The scope of my testimony, if you will, today, I've been asked to address in general terms how the debt of a city or a county is affected by the creation of a new city, by an annexation, or by a de-annexation. And really, I'm going to focus on cities and just cities and counties in particular, but the same principles apply for the school districts as we just heard from those folks. However, I encourage you to interrupt me at any time or ask any questions on topic or off topic. My mentor was a guy named Bob Steed. I don't know if you knew him, but he was a humorist and funny guy. And it was at a meeting and he got called on and he stood up and he said yes. And he basically announced that he was prepared to speak on any topic. So that was my mentor. So whatever it is, I may not know anything about it, but I'm not afraid to speak about it. So before I get into some of the nitty gritty, I wanted to give you kind of what I consider an executive summary. The issues relating to debt are relatively straightforward when you're creating a new city or when a city annexes property. However, the issues relating to debt are more complicated when the property is de-annexed from a city, and in particular, when the property is de-annexed and then you take all or a portion of that property and you create a new city. Many more complexities exist in that situation, and also they exist in the situation with the school districts. The complexities were illustrated by the Eagles Landing situation, which I know you all are familiar with, and the proposed Buckhead situation, and again, a lot of the city school talk we just heard. At the end of the day, the legislators and the affected governmental entities need to balance the interests of three parties. You've got the interested in the people that lived in the two different taxing jurisdictions, kind of the before and after. And you also have to weigh the interests of the bondholders. And I think to a certain extent, they get lost in the discussion. I think they were certainly lost in the discussion in the Eagles Landing legislation. But if you balance those interests and use a measured and thoughtful approach, I think you're gonna achieve the right outcome, and one that doesn't unduly penalize either the taxing jurisdiction and also doesn't penalize the bondholders. And if the bondholders aren't penalized, in other words, the security is not changed, nobody's ratings are going to change, and that's another issue I know that you'll ultimately be focused on or should be focused on. And when I was preparing to come in today and just thinking about these issues in general, one of the things that came to mind was the mergers of independent school systems and cities and county governments to form consolidated governments. And I said, well, that certainly has some precedent, right? And so I went back and I looked at some old legislation that proposed to merge Americus. And I looked at the legislation for a couple of the cities that were consolidated. And in those instances, what the legislators and the governmental entities decided is each of the issuers should keep their debt. Hang on to, you stay responsible for the debt that you issued before the merger. And obviously, the governmental entities didn't mind because no debt was being shifted from one party to another. And the bondholders were happy because the security didn't change. And I'm not saying that that's the right result for every situation that you all are going to face, but it's certainly, I think, in that context, represented a thoughtful, measured approach where those three different groups, their interests were balanced. So let's jump to the first one, the creation of a new city. As I indicated, that's pretty easy because the new city is newly created, so it doesn't have any debt, right? So you're just focused on the county debt. Well, what should happen is as the city limits are expanded, the county, the residents of the city, everybody remains liable. What I'm trying to say is everybody remains liable on the county debt. Nothing changes. There hasn't been any shifting of the tax burden from one entity to another entity because the county debt is there before the new city was created, and it's there most often after the new city was created. So nobody's harmed, no one's complains, and that's why you typically, you guys don't hear a lot of, moaning, if you will, when a new city is created. Again, because no one is harmed.
I'm sorry, you're talking about when,
This is,
you're not talking about when an existing city annexes, you're talking about when a new municipality.
this is you're creating a new,
unincorporated.
right, from cloth, right? And so,
But I
and
think you're drawing a distinction between creating a new city from unincorporated area, and that's what you're addressing now versus
Correct.
creating a new city from an already
right.
incorporated.
So I want you guys to understand the framework, because it's sort of a, it's a broader framework. And sort of, why do we, when we create a new city, why aren't there as many problems versus, when we de-annex, or when we de-annex, the proposed Buckhead situation, right? So when you create a new city, for the most part, things are pretty seamless because the debt hasn't shifted at all. All right, when there's an annexation and the city sort of grabs, I'm using inflammatory words there too, but when the city annexes and has gains new territory, who's affected there? So basically what happens in that situation is the residents of the annexed land become liable for the city's outstanding debt. You follow me? So if I'm basically asking to be annexed into a city, I now pick up debt that I didn't, let's just say in the easiest context, general obligation debt. I didn't vote for that city to issue debt 10 years ago, but now I'm going to pick up my pro rata share of that debt. The members of the old city limits are happy because that debt's being spread out, among more people. The county's not affected for the same reason the county's not affected when you create a new city, right? So the county doesn't care. The people in the old city don't care. The bondholders don't care because they actually have more collateral now for that debt because the digest has grown. So everybody's happy. The only person that could possibly complain are the residents that were incorporated into the new city limits, but presumably they asked for it. So again, if you're balancing all those interests and that's the outcome, that seems like the right result. And when I was looking through the annexation laws, because I don't do a lot of annexation work, I just do the debt issuance work. But one of the things that jumped out at me was 3636-7. And it was really the situation where if a city, and you guys might know this already, but if a city annexes land and the county has physical assets located, in that area, basically what the code section says, the county continues to own those assets. That was a question earlier. However, the county has a right to put those assets to the city if the county can no longer use them. So I think that's when you're deciding what to do about the city situation, there's at least some kind of precedent. And then I'm assuming what would happen in that scenario, if I'm a county and I say, okay, I can no longer use this building, city, you got to buy it from me. Then presumably what the county would do is take the money and pay off the debt. So we talked about creating a new city from whole cloth. We talked about an annexation, a de-annexation. So in the de-annexation, it's interesting in my mind, really creation of a new city or an annexation is almost like a marriage, and a de-annexation is almost like a divorce, right? So the one is a lot easier to deal with than the latter, than the other. But in a de-annexation, and there's no creation of a new city, what I think should happen is, I think that the people that are leaving the city voluntarily should remain liable for the existing debt of the city at the time they leave. Now, I don't think that probably happens in practice because I think it's very difficult to administer, and there's probably not that many de-annexations, y'all may know, but are there a lot of de-annexations? I'm not familiar with that many. So that's why I think it probably never hits anybody's radar. There's not that many, they're small, so anyways. So now let's talk about de-annexations, then followed by the incorporation of a new city with some of that land that was annexed. I believe, my personal viewpoint is, I believe the outstanding debt of the old city should be divided between the old city and the new city on an equitable basis. This is fair to the residents of the old city, the residents of the new city, and the bondholders. If you don't do that, then your ratings could be adversely affected. Now, the question is, the thorny issue is, what's an equitable division of that debt? And that's for y'all to figure out. But let me go two opposite extremes. So one, I'll say it's by future use, and the other is by digest. Okay. So let's use an example. Let's say that a city has 500 police officers and has a $25 million police training facility, right? And so property is de-annexed, and that debt is outstanding. Property is de-annexed, and the old city isn't going to reduce its police force. It's still going to have the same number of police officers. So there's an argument where you could say, well, then the old city should just keep all the debt because it's going to need that entire facility, right? The problem with that is you've changed the credit for the bondholder. And is that the most equitable result? The opposite end of the spectrum would be, well, even though the new city isn't going to use it at all, and the old city is going to continue to use it, what we're going to do is the new city is going to pick up its pro rata share of that old debt, and we're going to we're going to divide it based on our value of our digest, right? So if you're losing 40% of the digest, you'd assume 40% of the debt. Now that's probably not fair from a dollars and cents standpoint to the new city, but the bondholders are going to be happy, and it's the fairest to the old city. So those are just examples of where the old city keeps 100% is one end of the spectrum. The other end of the spectrum is you tag the new city with its pro rata share of the debt based on the digest, even though it's not going to use the old facility. So that's kind of the overview of what happens to outstanding debt when there's a creation of a new city, an annexation, a de-annexation, and a de-annexation followed by the creation of a new city with a portion of that property. You want to ask me any questions about that? Or I know the ad valorem property tax abatement have come up a lot. If you want to talk about that, we certainly can.
Okay, recognize Chairwoman Oliver.
I interpret your comments that you conclude that the citizens of the city of Brookhaven, Stonecrest, and Dunwoody owe the pension liability for DeKalb County employees that were employed at the time those cities were created. Did I interpret that correctly?
Yes. So the pension liability is, as you know, is a tough question. But if the county is going to continue to provide, services to those cities, some services, which presumably they are, the county continues to provide some services. So on that front, it would be, that the cities would continue to be responsible for the county pension liability, just like they would be liable for the county debt. Like, for example, if the county issues general obligation bonds for parks, well, everybody in the county can use those parks, and the county can continue to levy a bond millage and pay back those bonds on everybody. So I think the harder one is, what do you do with the city?
When you
pension
have a new
liability?
police force in Brookhaven, a new police force in Dunwoody, but the pension liability exists for the old employees in the tune of $20 to $30 million.
Yeah, and it's the same thing to do with the city. If you were, if you were de-annexing and then creating a new city, you probably, as a practical matter, what you're going to have to do is you're going to have to close off this pension, figure out what the pension liability, unfunded pension liability is as of that date, And then again, allocate it on a reasonable basis, whatever you think that is. And then these folks would start a new pension, and then the new city would start its own pension. So yeah, I think that's what would happen on the pension liabilities.
Thank you.
Anything else?
Any other questions on the part of the committee? Yes, Rob.
So Roger, I'm trying to make sure I understood what you were saying earlier, where you were talking about residents remaining liable. And of course, I'm playing semantics. But
This is when you create a new city and the county, it's my example. So the county issues bonds for parks and recreation, builds them all throughout, all throughout the county, right? So just because you've created a new city here, the county still levies a countywide tax to pay those general obligation bonds. So we shouldn't care as a general rule. I mean, there's exceptions to that. There's special service districts and all kinds of stuff. But as a general rule, the county's like, well, I don't care because I'm just making this up. We levy 2 mills. We levy 2 mills a year to pay our bonds. We're going to continue to levy the 2 mills on everybody,
including the new municipality,
including the new
annexed area.
Yeah.
But when you were saying liable, you didn't mean they individually liable. You meant their property still remains
Yes.
subject to
Correct.
the income or
Correct.
that's generated for the county by virtue of their ownership of that property
Right.
still is available to service that debt.
That's correct.
Okay.
That's right.
You were talking about consolidations too, I guess, where two governmental entities consolidate.
Mhm.
How could they stay liable? I mean, wouldn't the new government just be responsible for all the debt of those? two
No,
entities?
they created special taxing districts. And so they basically said, okay, we're going to look at the city limits and what the digest is, right? And we're going to say, this is the special taxing district, the city as it exists right now. And then there was the unincorporated county, and they basically had 2 separate special taxing districts. And it's my understanding, like in Augusta, Richmond County, you get, if you used to live in the
Or if you live in what
city
used to be
limit,
the city limits,
you
you have a
get-
1 millage rate that's based on that special district.
to
service
pay
all-
off the old debt. That's
all
right.
debt.
Yeah.
So that would be created, and then you just have different taxing districts just try to service the debt. Do you have
Right.
to go back and amend your bonds or revalidate the bonds, or you just come up with the taxing districts and as long as you're
Yeah.
doing that to pay the bond, do the bondholders have no?
Right. And
issue
the reason is, Rob, is because what you told your bondholders is, the city or the county was going to levy an unlimited tax based on its, so
To
the
meet the debt
taxing
service,
district
yeah.
is the same, right? So we
Okay.
haven't decreased it. So the bondholders don't care. They're keeping the same credit. that
So it
they-
doesn't create any legal issues with
Right.
respect to the bonds or getting consent of bondholders?
No. And so in general obligation bond issues, the very simple, basic documents, there's no covenants not to merge or acquire or whatever. It's just basically, we promise to pay and we're going to levy an unconditional and unlimited tax to pay these things. In revenue bond issues, you can run into some different issues, but for the
Well, and
most
usually
part,
that's tied to one particular project on one particular
Yeah.
patch of ground. I
Yeah.
guess, so.
but there's really nothing in general obligation bonds that's going to get tripped up as a general rule by any of the stuff that goes on, other than a potential downgrade in the credit or the bonds.
So when you're saying that these residents should remain liable for, are you basically saying there should be a special taxing district that
Yeah.
would still
That's,
service that debt?
yeah, that's the kind of I would defer to legislative council how they would propose handling that, but that's certainly the way it was handled in the past.
Okay.
Is that you would create the special taxing districts and do it like that.
Okay.
And I just, and then at the end of the day, something either feels right or it doesn't feel right. And if you got to call balls and strike, and if you basically, somebody's going to figure out how to do it so that it's fair and it's legal and, I don't know. I'd like to believe everybody could play in the sandbox nice together, but
Okay.
any other questions? Did you want?
I believe we have one other question from Chairwoman Taylor, and then I think Stewart from Legislative Council has wanted to come. Oh, you think? Okay, then
Okay.
Chairwoman Taylor.
Just a quick question, and it has to do with length of time. How long do bonds last, and would a new city be obligated for 30 years if you got a 30-year bond? How, I want to know how that would affect something. 'cause it links
So
on.
general obligation bonds, and those are the tax-backed bonds. So that's principally what we're talking about. The longest maturity they can have is 30 years. Very rare that they're done for 30 years. They're usually done for, I would say, anywhere between 10 and 25. And then you could always have the option of, sort of prepaying your share up front if you could come up with a bunch of cash or another
Right.
financing method or something.
Well, one of the things I was thinking of Hall County, when
Mhm.
they needed new facilities, if that was one of their issues, how long is a bond to build like a new high school? Is it going to be a 30-year bond?
Yeah, they can do, so what the schools do mostly now is they do pure general obligation bond issues, which are secured solely by ad valorem property taxes, and you levy a separate millage rate to repay those bonds. Or they're doing general obligation sales tax bonds. So if the county or the school district has done
Yeah,
a SPOS or an
yeah.
ELOS, we call it, and those are repaid over 5 years.
Okay.
So, what the point he's trying to make is if you don't, well, they could always go to the voters and get approval for general obligation bonds, but then if your digest isn't really big, it's a huge millage increase, right? That's the way it works. So if you're a poorer county, and let's say you say, oh, we have $100 million, we need $100 million to build new school facilities. Well, all of a sudden that $100 million, if your average price of a house isn't that great, it results in a huge millage increase. And so that's just politically harder.
How would any of this that we're talking about, I'm going to bring in another awful subject probably, but I come from a rural area and we have a number of rural county hospitals and they have lots of debt. And how is something like that going to figure into this calculation? Sorry, but that's an issue.
Yeah. So, really just depends who owns and operates the rural hospitals. A lot of them started, they were county owned. Then eventually they were transferred over to hospital authorities. Habersham knows this well, that they're transferred over to hospital authorities. And then quite often the hospital authorities then entered into leases or long-term contracts with nonprofit corporations. There's a lot of consolidation in the healthcare industry, and it's really hard for rural hospitals, to hang on. So the communities that are choosing to hang on to their rural hospitals are having to guarantee the debt or
Right.
levy a millage rate. You're allowed to levy up to 7 mills to support hospitals. So they're having to levy a separate millage rate, for the hospital. And
One of my rural counties did have to, it wasn't 7 mills, it was 4.
yeah, you can do up to 7, but 4 mills on a tax bill. So as you know, on
That's
an
a-
average tax bill, you've got, if it's just city and county, a lot of times school districts are usually at 20 mills and the counties, let's just say 10. So it's probably the average tax bill is 30 mills. And if you have a city on top of that, maybe another 5 or whatever. But if you're a county who's levying, 7 to 10, which is not uncommon, you do 4 mills, you're almost doubling the taxes. Yeah, socking it to them to keep that local hospital. But a lot of times it's a big employer, and politically they want to do that. But it's
Well,
just,
you can't. If you lose your hospital in a rural community, you lose your employer base. You
right.
can't get
So
new
what attracts
businesses.
employers is
Right.
schools and jobs, right?
But my concern was if you would have a county hospital, how would you ever divide that if they decided to annex in part of it? Again, I think that's something that needs to be considered into it.
Yeah, so the county
Yeah.
hospital is basically falls under my category of county debt. And the county debt is largely unaffected by
Okay.
this.
Okay, thank you.
Okay, any other questions for Roger?
All right.
Thank you, sir.
Okay.
Now we're going to step over to a little bit different subject, but very similar to what's been brought up a lot this morning. Talk about county revenue loss from annexation. I'd like to invite to the microphone Mr. Clint Mueller with ACCG.
Thank you, Mr. Chairman, members of the committee. My name's Clint Mueller. I'm the legislative director for ACCG. We represent the 159 county governments across the state of Georgia. I think you have in your packet a handout. It's a one-pager. If not, I've got some extra copies. Looks like this. It's got ACG's logo at the top. I'm going to be referencing that in my discussions here this morning. I was asked to speak on revenue that transfers from a county budget to a city budget when an annexation occurs. This same type of discussion would be related to an incorporation of a new city too. So if a new city is created, there's revenues obviously that would transfer from the county budget to a new city. So that's why at the top of this, I've got annexation and new incorporations, because most of what I'm going to speak about today is applicable to both. I don't think you can have a conversation just though about the revenues without also talking about expenditures or service delivery burden. So as you know, in a budget, there's two sides of the equation. There's the revenue side and the expenditure side. And if you're transferring costs that equal sort of the revenues you're transferring, that makes sense, right? If I'm giving, if another jurisdiction is getting $100, but they're also picking up $100 of service costs, makes sense. I think where we have some problems is a lot of these revenue sources that I'm going to talk about, there's not a direct connection between the revenue and the services that they fund. So when you're talking about things like fees, right, there's a direct connection a lot of times, like a 911 fee. You know, if I'm paying a $1.50 911 fee and I move from a county system to a city system, my $1.50 goes to the new system who's now providing me that service, kind of like what we talked about with some of the QBE funding for the schools that follow the children. But there's other revenue sources that don't follow the services. So in my example here, you're going to see two types of cities here. I'm going to call the city on the left, City A, which is sort of a full service city. They're providing all the services that a city could probably provide. And a lot of the heavy cost services that they're providing are things like police and fire and roads and bridges, things of that nature. Then on my right, I've got City B, which these are legal, right? And under Georgia law, you can have a city that only has 3 services. And let's take a city that does planning and zoning, building codes, and basically solid waste or garbage collection. That's all they do. So they're leaving the bulk of the services to somebody else, in this case, probably the county. With either scenario, City A and City B are going to be able to pick up all these revenue streams that are below this. So these revenues that I say that are transferred from the county to the city, they get to pick all those revenues up just by virtue of now I'm a city. But as you can see, though, the service cost, the service burden they're taking off the county is very different. Let's take fire, for example. City A is picking up fire service, which is a costly service. They're also getting the insurance premium tax revenue, which is one of the ways to fund fire. That makes sense. City B is not picking up fire. Maybe the county continues to provide that fire service, but they are picking up the insurance premium tax revenues. Why? Because insurance premium tax revenues are not tied to fire services. Insurance premium tax revenues are tied to population. So by virtue of them picking up additional population, they pick up more insurance premium tax revenue. I should have said this from the outset, though, the one revenue source, and this was talked about in the previous discussion about bond indebtedness, the one revenue source that doesn't change is the county general M&O tax levy. So there's a county general M&O property tax levy, and that's across the board. That's inside the cities and in the unincorporated area, that's the same. Now, in a little bit, I'm going to talk about special districts, which is different. But the general M&O levy, that's what doesn't change. When you annex a piece of property into the city, the county is still going to get that general M&O levy. So a lot of times when people say, well, the county's not losing anything, they're really talking about, well, you're not losing out on any general M&O property taxes. And that is a true situation. That's a true case. But with these other revenues that we're going to talk about here, that's not the case. Those transfer from the county's budget to the city's budget, regardless of the type of services that the city picks up and the service delivery burden that the city, new city or an annexing city takes off the county. So insurance premium tax, business occupation tax, cable franchise fees, alcohol taxes, hotel motel taxes, licenses and permits, title ad valorem tax. This is a little different animal. So with your TAVT that you pay on your car, the General Assembly just recently changed that formula on how that's allocated between counties and cities. So if somebody is annexed into a city, they're still going to pay some TAVT to the county, but they're not going to pay as much as they used to pay. So the percentage, once you get annexed into the city, the percentage for the city part of the TAVT goes up. The percentage for the county part of the TAVT goes down. So it's not a complete loss of revenue in that situation. But it's a partial loss of revenue in the situation of TAVT. And then you've got even grants from the state, like LMIG grants. So part of the LMIG formula, it's not just lane miles, but it's also population. It's a combination of both of those statistics. And so the city may or may not be picking up the road, right? They could, and we've already had this discussion, I think, in some of your other meetings about whether they pick up the road or not. In some cases they do, and in some cases they don't in an annexation. But they're definitely a lot of times picking up the population. And so they're going to get more LMIG funds. And you all may not be aware of this, but we have a number of cities that actually do not have any roads that they support directly, but they get LMIG funds. Why? Because they've got population and they get it. So they have to basically contract with the county, if the county is the sole provider of roads in that small city, to basically do any kind of road maintenance that they want with it. But they're still eligible for the LMIG funds, even though they may not actually do any road maintenance. And then the last one is impact fees. This is usually a revenue source for some of our higher growth counties, but the county cannot charge impact fees inside the city. And there's certain things that we can charge impact fees for, but once an area gets annexed, they no longer can get those impact fees from the annexed area like they once could. So all the things that I've covered in the top list, those are things that definitely are going to transfer from the county budget to a city budget in an annexation or in a new incorporation. The things at the bottom here in this last list, these are things that might be impacted. It just depends, because a lot of these things in this last list is up to a negotiated formula between the county and the city. So when you talk about special purpose local option sales tax or loss local option sales tax, for those of you who aren't familiar with loss, it has to be renegotiated every 10 years for the counties that have it. We're coming up on a new renegotiation that has to be completed by the end of next calendar year. Well, in those loss negotiations, they can decide how they divvy that money up between the county and the city. So a lot of times it's based on some sort of a population type of formula, which if that's the case and the county's only getting a share based on its unincorporated population, then obviously annexations and corporations would affect that. And in fact, a city that I think brings in more than 15% of the current population, or any new city, it automatically opens up that lost negotiated agreement, and they have to renegotiate that. And so those are filed actually with the State Department of Revenue, who collects the tax and remits it to the counties and cities. They're going based on that distribution certificate. And so these things could have impacts on something like a lost distribution certificate. And special districts, I think that was mentioned earlier, but remember, a special district could be funded through special assessments. It could be funded through fees. It could be funded through property tax. But it is to serve a sub-geographic area of the county, maybe unincorporated, maybe more than the unincorporated area. But let's take fire, for example. And I know, Representative Thomas, you've got a county that has fire in the unincorporated area, but they also serve some of the cities with fire, and they charge a special service district in Cherokee County. It's a fire tax. It's I think it's about 3 to 4 mills of property tax that they charge to fund the fire service. Well, if a city that has fire annexes, guess what? They've now changed that service district. The county can't charge that fire millage to somebody that was in the unincorporated area that now has been annexed into the city, because now they're getting their fire service from the city, not the county, which makes sense. The service is transferring, so they shouldn't get the revenue. However, it does affect things like, where the fire station is located, or they lose some of the economies of scale because their overhead, they can't reduce their overhead, even though they've lost some of their fire service customers. So there's those issues to consider. But so the items that are in that last list are things that could be affected. The items in the list above it are the things that definitely will be affected. But those are some of the revenues that definitely will transfer over from a county budget to city budget. So you can't just look at the property taxes. Yes, the property taxes, the general M&O levy is probably our largest revenue source. And it's not affected, just like the bonds, geo bonds. Why are geo bonds not affected? Because they're usually based on that general M&O levy. It doesn't change. Now, if there's a bond levy that's based on some sort of a special service district levy, that could potentially be impacted. So with that, I'll be happy to answer any questions that you have of me. I hopefully have provided some clarity and not confused you more.
Okay, thank you, Clint. Questions on the part of the committee? Representative Levin.
Thank you, Mr. Chairman. Clint, you were talking about the special districts, and that's something I'm not as familiar with because I'm in more rural areas, so we don't have special districts really so much. But would those, I thought those would stay the same regardless of an annexation. Are you saying an annexation can change the district?
Yeah, so special districts obviously are allowed under our Constitution, but think about a special district as a way that a county can provide city-like services without having a city. So in the case of Cherokee County, the unincorporated residents want just as high a level of fire service as people that live in Woodstock or Canton. And the county provides that higher level of service through a special service district. But that service district goes along with the service area. They legally cannot extend that service district into a city unless the city gives them permission to do so. So they do provide it in some of the cities in Cherokee County, but it's at the will of the city. The city has asked for that and the county's agreed to do it. But any of these services that you see on this list on the left, those are under the supplementary powers in the Constitution. Counties can't just go in and decide they want to do it, right? So if my service district for fire or police included an unincorporated area and the city annexes it or new cities created in that area, I've got to get permission as a county now to continue to provide that service. Otherwise, if the city says, no, we don't want you in here, we want to do it ourselves, or we don't want it at all, then I've got to I as a county have to come out of that area because that is not my legal territory anymore to be able to provide these types of
But
services.
wouldn't you still get any revenue associated with that district? Because the district, I guess what I'm asking is, does the district automatically get changed for purposes of collection of that enhanced millage rate when the city annexes part of that district or annexes?
Unless the city agrees differently, then yes, the county can't continue to collect, in the case of Cherokee, a fire millage tax inside a city that has said, we don't want you here. Yeah,
Even if it was initially a special.
Even if it was
district prior to
initially in there,
annexation.
right? Because initially they were under the county, they were unincorporated residents, right? Now they're no longer unincorporated residents, they're residents of a city. And they get their services, in this case, maybe fire, from the city. So the city said, we don't want you here. So all of a sudden that millage rate, that 4 mills that they were paying on their tax bill for being part of that special fire district, they're no longer going to pay that in the future. So the county's going to lose that fire district 4 mills from that tract. That's correct.
But presumably you would not then have to provide the service.
That's right.
Okay.
That's right.
To that particular property.
That's correct.
Okay.
It could affect, obviously, I mentioned, your overhead and other things that you still got to provide.
Yeah.
You lose some of that money, but you're right, to the individual property, you no longer would be providing that service anymore.
I guess it would seem to me, and again, my experience is usually not dealing with these annexations where you annex 300 acres and you put in a subdivision. So there I could see that these numbers would vary a lot. But for annexations that are 1 or 2 tracts at a time, while you will see some changes, it's not going to be that substantial, is it?
No, for small, single pieces of property is probably not going to be that much.
In terms of revenue impact upon a county.
Right. This is really going to be probably more of an issue when you have like an incorporation of a new city, because then you've got a large territory you're not annexing, you're incorporating all at once. Yes.
Okay. Thank you.
Okay, thank you, Representative Leverett. Representative Thomas? Oh, wait, okay, sorry, didn't catch it. Any other questions? Seeing none, thank you.
Thank y'all.
Next, I'd like to invite to the microphone Mr. Tom Gale, Director of Government Relations for GMA.
Thank you, Mr. Chairman, members of the study committee. Tom Gale with the Georgia Municipal Association. So thanks for having me today. I was put on the program, I guess, to provide a counterpoint to my colleague Clint Mueller's comments. And I guess sort of the fundamental question that you all have to ask is, should payments for services and taxes go to the jurisdictions that are actually providing those services or not? And so, yes, some of those revenues that the counties receive, whether it's local maintenance improvement grants or insurance premium taxes, alcoholic beverage licenses, if an annexation occurs, yes, they will go to the city that annexes the property. But again, it's a fundamental question. Should those taxes, those fees continue to be paid to a county that's not going to be under obligation to provide services, and in fact is specifically prohibited by the Georgia Constitution from providing services in the city limits without a contract with the city? And just to sort of use one example, Clint mentioned the local improvement, the LMIG program, the local maintenance improvement grant program that is administered by the Georgia Department of Transportation. Cities may not have their own road department. They may not have the public works department that has graders and paving trucks, et cetera. But they get money from LMIG. They then contract with the private provider, or if the county gives them a good deal, contracts with the county with the money they get. The county shouldn't just get that LMIG money because it used to be part of the county and is now part of a city if the city's in charge of owning those roads. So, I think it's been hammered home by Mr. Murray and of course Clint too. None of the properties that are entering into a city through an annexation ever leave the county. They never leave the county. They always are on the hook for county property taxes that pay for some of the more traditional county functions like the health department and courthouses and the sheriff's department. So I'll be glad to try to answer any questions if you have any.
Okay, any questions on the committee? No question?
Thanks so much.
All right.
I'll see you in a little bit.
Okay. I started to say you're doing better at trying to get us back on schedule here. All right. Next, I'd like to ask Ms. Gina Wright to come to the microphone. Gina is the Executive Director of the Legislative and Congressional Reapportionment Office, an office that is on everyone's mind right now.
Thank you, Mr. Chairman, members of the study committee. I appreciate you asking me to be here today to speak to you about how my office has connections with annexations and how that impacts what we do, which could impact somewhat what you do. And I promise not to talk about taxes, bonds, or fees. So I'm going to reorder what I was going to talk about a little bit in relation to what was mentioned earlier with independent city schools. With independent city school boards, those members who are elected to represent those boards, they actually have to have legislation. If they run by district and their districts elect those school board members, they have to have legislation to redraw their district maps, which is where we are involved in the process. What happens sometimes, though, if the annexations that they have done have happened since they turned over their most recent municipal boundary lines to the Census Bureau through the Boundary Annexation Survey, then perhaps what we show for their city limit boundary lines might not be what their city limits are currently. And we do need those to reflect and have the correct population figures. It's when we redraw, we want those districts to be balanced in population, which means we need the right number of people. So what the problem with that is that we just don't know, and we don't have a way to guess what those additional annexations may have brought in if it brought in resident population into those independent city school board maps. So that's just a side effect of how with independent city schools, we're involved a little bit with them. It's just the redrawing of those district lines, which will have to come through the General Assembly with legislation, which is different from city councils. City councils can actually redraw their boundary lines under the home rule provision, and they don't have to come through the General Assembly to redraw their maps. So independent city school boards are just a little bit different in that respect. And there are the 21, not all of them, I don't think, run by districts. They may have some at-large boards for those independent city school boards, but the ones that do, we will have legislation. So hopefully, if we're doing this soon, like we hope we will be doing in the next year or two for these local jurisdictions, that the city limit lines are hopefully pretty close to being what they really are on the ground. Hopefully there haven't been a lot of annexations in the time that they had to give those final boundary lines to the Census Bureau. So hopefully we'll be able to not have too much of an issue. But if they were to delay and get a little further down into the decade before they look to redraw, we could bump into the issue of, oh, they've taken in and annexed some territory, but we're not able to tell you exactly how many people in terms of census geography that is. So we go with the best number we have, which is what would be the 2020 count, whatever they were given for their 2020 count. We do include, legislative council includes some language in the bills when that kind of thing happens to make sure that if any part of the city is not shown in the map or included in the description, that it is to be attached to the part of that city where it would be contiguous. Now, again, we don't know how many people that is. I think the wording actually specifies if it's touching two districts, then it would go into the lesser populated district, something like that, that it would, whatever it touches. So we do kind of cover it with language, but that's where we bump into, well, if we don't know, we just kind of are hoping that that's not an issue as we draw those maps. So that's where annexations affect us with actual district drawing, but a couple of other topics that are kind of different. They're all unrelated in a way, but just places where annexation crops up with my office. When you do a legislative annexation, when you draft a bill to allow a municipality to take in some area, they can provide a description to legislative council for that legislative annexation in different ways. They might give you a parcel listing that just has a long list of numbers that just tells you where that is and how that's defined by their tax assessor in their county. It could be a meets and bounds description that was a surveyor did that talks about so many degrees to a point, and then it turns, and then it's this, and it's some kind of a description like that. That may be what they submit as well to have drafted for that annexation. And as your mapping resource for the General Assembly, what I can tell you is when those types of descriptions come in, my office does not have a way to create a visual interpretation of that for you. If they are that type of description, we don't have parcels, tax plats, or any of that kind of stuff that we use in our office and in our system. And we don't have any way to measure to a pin and, and tell you where that is. I don't know where that is. So what we use for drawing our maps and our resources is census geography, which is based on features you see on the ground. So it's census blocks, which are defined. They're the smallest level of geography we get from the Census Bureau. Most of those blocks are defined by physical features, roads, railroads, creeks, power lines, pipelines, things like that, those kinds of things that you can see. It's not necessarily a huge deal. There are times where we have drawn annexation maps for cities that, you know, they want to do an annexation, they want a legislative version, and they want my office to draw it for them. And they use blocks and geographic features, and we've done that. And we can do that if it's going to follow those features. If they know they want to go all the way out to the interstate or whatever, and we can match that in geography, we can do that. We can create a description just like we would for any other redistricting map. And the legislative council can draft that, and it can be done the same way if they want it to align to those features. If their annexation is, we're taking these 3 parcels that are along the northern boundary of the city, we don't have a way to reflect that and to show you a visual of that. And I know there's been perhaps some discussion about requiring them to provide a map when they send that up here, so you'd have something to look at to know what are they annexing, what does this look like. And I think that's a great idea. I would love to be able to provide that for you all, but we can reproduce it if they provide it. But as far as creating something to reflect it, if it's a parcel listing or a meets and bounds description, there's not really a good way for us to do that. Along that same line, we do not maintain a record of or geographic files of annexations across the state. So as cities annex, and they do frequently, there is no requirement for them to notify my office that they made an annexation, which is fine because that's not really my primary objective, is to keep up with that. However, it does sometimes come up with questions with when we draw city council maps, which we do, even though they don't have to have legislation, we still work with them, and other issues where we bump into city limit questions and things like that. It is my understanding that the municipalities are required to submit those changes to DCA. I think they are required to do that. And it is my understanding also that Georgia has a particularly unusual relationship with the Census Bureau in relation to the boundary annexation survey, whereas we are the only state that I think our relationship there is that DCA notifies them that this particular jurisdiction has made a change to their boundary, but they don't tell them what it is. And they don't tell them, give them a file or anything. They just say, this city has made this change, or this county has made a change if there was a boundary dispute. And then they leave it up to that particular jurisdiction and the Census Bureau to work out what that is, to input that change. And we also, my office encourages local groups to always, if there's a boundary change, notify the BAS is what we call it, the Boundary Annexation Survey of the Census Bureau. Our geography, what we pull from the census, comes from what updates go to the BAS. So of course, that's our method of getting those new updated boundary files. Now, the census used to send those out more frequently during the decade. We would get like a new city layer that would be all the cities in the state, and it would show updated boundary changes. That's not as frequent anymore as it used to be for, staffing purposes and whatever their issues are up there. But we do occasionally, at least once a decade, get an updated file, which is useful. It doesn't come with new census blocks or numbers, but it does allow us to show it on a map. At least if they've annexed, we can show those new changes. I don't know if it's something that the committee or the General Assembly would want to consider in putting any language in annexation bills that might encourage or require them to submit to the BAS to make sure that these files are being provided, because if not, there's nothing that really makes them do it. We just hope that they do, or the DCA, I don't think DCA makes them do it either. I don't know how that works with their relationship, but it would be useful to know that they are turning over these updated file changes to their boundary so that we have that and it comes back to us in the correct version as they make changes. And that's even with county boundary disputes as well, would also be very useful to make sure that any changes that actually happen or agreed upon between two counties and they work that out, that we get the correct boundary line, because that helps us obviously with what we do in our office. Changing gears a little bit. When we draw district boundaries, which obviously is something you're interested in, district boundary lines, when we read district, a lot of times we do not use municipal boundary lines as a district line. And the particular reason is because of annexation. If we were to right. And if we were to put a, district line and we had to divide a particular county because it was too large to be in one district. So we decided to go through and had to put two house districts that touch each other in that county, we would not choose to follow around a city limit line simply because the possibility that city might annex beyond that line, just because a city annexes territory into that city would not change the house district line. The house district line would still be wherever it was on that block geography when it was adopted in the legislation. That's where the boundary would be. So the effect of that would mean that once that annexation goes in and it's beyond the district line, that the district line then would still be on a former city limit boundary that might be an invisible line that doesn't exist any longer, which causes some problems for that county and that elections office down the road to know where was the line, especially if they have turnover. A new election supervisor comes in and says, what is this feature? I don't know what this is. How do I divide this area? And a real life example of that actually happened when federal court came and had to redraw the House and Senate lines in 2004. The special master who redrew those districts was from another state that prioritized city limit lines. That was a very important thing. And so that is what that particular special master chose to do, which led us to this consequence down the road as those cities that had been district line boundaries annexed beyond it, and county election offices said, what do we do? Because the line is not there anymore. And I said, well, I'm sorry, that's the line. You have to know where that old city limit line was, because that's your House district or your Senate district line. So we try not to use those features because of that reason. It could be difficult down the line to know where was the line supposed to be. So that reason, what we typically would use is more the precinct boundaries. Typically precinct boundaries, counties define those on geographic features. It makes it a lot easier. So when we have to divide, we tend to use those more than city limit lines just because of the unpredictability of where they might be. Connected to that is the fact that there are counties who use their city limit lines as their voting precinct lines. There are some counties who have made the decision, each of the 159 county election offices, they define their own voting precinct boundaries within the county. And they make the decision what works for them. And for some, they feel as though their municipal line that's the way they like their precincts to be, because that way then they have a city election. It's just all these precincts, or this one precinct that is this city, or two precincts that splits this city and nothing else. So they wouldn't have to open any other precincts. They could just do the city election there. Now, through the years, I have suggested to them that they don't have to do that. And because of the issue I just mentioned, it might be better to use some geographic features and spread the precinct out so that you're not dealing with that. Because what they have to do is every time a city annexes, they have to go in and change the precinct line in order to keep it in line with the city limit line. Every time the city limit changes, therefore their county precinct line changes, which also means for those people, they're changed from one precinct to another when they're annexed into a city, if that happens for them. So it does cause them the issue of having to keep updating the precincts if they choose to do that. That is their decision down the line. And what side effect of that too is the fact we can't follow the geography when they make those changes to the precincts. And if they follow the city limit lines, then a lot of times we can't duplicate the precinct line that they've now used a new city annexation for. So that kind of puts us in a, we do the best fit we can. But if we can't duplicate the line they've just created, then we just tell them, as your city annexes, if you're changing your precinct, then we're going to just have to leave the precinct as the best we have it until we, can make something that matches up with it. So it does, annexation does come into play a little bit with what we do. It does have some effect, nothing too drastic, but there are places where we can definitely interact with the cities and counties as a result of how annexations and de-annexations as well come into play with what we do. So if you have any questions, I'd be glad to answer them.
Okay, recognize Chairwoman Taylor.
Thank you very much. Just a couple questions, and it has to do with what you were just talking about, the precincts. And if you have the population growth in certain precincts, is there anything in the state law that says you have to move them? Do the precincts have to be a certain size?
You're talking about population size?
Right, based on population size.
There is some number in there. I don't know if they've changed. I'm trying to think if it's changed and if how closely they adhere to that now, because I think as early voting became a thing, it sort of changed a little bit of the dynamic with that. But I wanted to say, it used to be 2000, but I don't
Okay.
think I don't know if that's still, do you know, Stuart? I don't know if that's
Okay,
still the
it's
number.
just because, again, elections will be coming up, but
Mhm.
more so than that, certain areas have grown more than others. And in our rural communities, some of them shrunk
Mhm.
and they may need fewer, whereas in the metropolitan areas, they probably need more precincts.
Right.
That's why I was wondering if there's a distribution number that they need to base it on.
Yeah, I'd have to double check if there still is. I think there
Okay.
used to be, but like I said, as early voting became more accessible, I don't know that number is still something that they hold them to when they have to set that. I have to double check on that.
That's the job of the county board of commissioners or the county election board.
Yes.
Thank you.
Okay, any other questions? Before we leave this matter, I'm sorry. Chair.
I've heard two items that are kind of in the bad news category. I won't know if I'm correct. I've heard
Okay.
your program hasn't changed, that you totally only rely on census data, census block data. So if Emory came to give you a new annexation, that was a meets and bounds annexation that they gave you?
When you talk about when Atlanta annexed that, we were not involved in the drafting of what they used for the mapping purposes of that. And after the fact, we could not reproduce that until the new 2020 geography does reflect what that annexation line was. As you know, it was a little oddly shaped and on parcels as well. I think we could cover most of it for geographic purposes, but not all of it because of the way that it was shaped.
And so the reason you know now what that meets and bounds, I think it was they hired and paid $1 gazillion to do a meets and bounds for that. But the reason you know now what it is because it was filed somewhere. And here's the second part of bad news I heard. There's no systemic way that tells me what a city has annexed. And do other states have some kind of central depository that keeps track of this?
Okay, so the boundary line, yes, they would have submitted that to the boundary annexation survey following the completion of the annexation.
Which they're not mandated to do.
They are not, that I understand, they are not mandated to do that. They are told to do that. I think DCA instructs them to do that when they are notified of the annexation and the boundary change. But I don't believe that, do you know, Stuart, if there's any law that says they have to do that? So that's the first part of your question. And the second part is if they are turning it into DCA, and I don't even know if there's a legal requirement for them to do that. DCA had a place, I know I was given the link at one point where I could pull it up online and see the list of annexations by jurisdiction. It had the city and the county name and some of the information, which is, just a really vague description. But at least you could tell if they had done something. I don't know how current they keep that list and where that link is even hid. It wasn't an obvious place to find. I had been sent that link from DCA, so I'd have to do some digging and see if that's even still active.
Because there's house by house annexations in my area.
Right.
Where is that recorded? Anywhere? Oh,
right.
Okay. Any other questions, Representative Leverett?
Mr. Chairman, I wanted to address that question because my understanding is in the annexation law, there is a requirement that a city report not only to DCA, but also include the annexed area in its census data that it submits or a map or so. There's some kind of reporting requirement, as I recall, where they have to notify somebody about that.
Well, I went to some legislation in prepping for this just to see if there was something in there, and the particular bills that I looked at did not have any language in the bill that said that. Now, if there's something somewhere else that says that, perhaps, but I'm not aware of it.
Well, are you talking about when there's legislative annexation?
Right, legislative
Yeah,
annexations.
that I couldn't speak to, but I'm pretty sure in the general annexation law, there is a requirement because I know in our standard ordinance we do in Hartwell, like any good lawyer, I just copied everything out of this code book. And I paraphrase, the requirements of the code section, put them in the ordinance, so maybe we'll see it and remember to do it. Now, are we really doing it? That I don't know.
I don't know
But-
either.
But I
With-
think we're required by state law to do it. And I think also in jurisdictions where people do the sort of creative type of law practice I do, we try to find something you can copy. We're required by city ordinance to do that, but I'm not sure if we're actually doing it.
And that may be the DCA requirement.
This is knowable and Stuart can figure out the answer.
Stuart can, he's looking for something. So he's in a book. It may be that the DCA requirement is where it is, and kind of some of my digging, that's what I was able to find, that they're supposed to notify DCA at least because they are kind of the repository of those boundary changes for, I don't know how that landed there, but that's where that had been going.
And it could be confusing too, but.
And I don't
thought
know,
there
as
was
far as the
something to do with
BAS, I
census.
was not able to find any information that says that they have to notify the Census Bureau of that for the geographic purposes.
Chairman, so the legislature has to, if there's going to be redistricting for a county or a school board or an independent school board, that has to be done up here by the General Assembly.
Yes, that's correct.
But cities through home rule can pass an ordinance to change their districts.
Yes, they can have legislation if they like. Some do, some because they want that legislative process. They want that action on their change to their map. So there will be some that we do that are for city councils, but they do not have to do that just for the council unless they're making any other change. If it's only a shift in boundary lines for the purposes of redistricting to balance the population of the districts, they don't have to. If they change the number of members on the board, they change the terms, the structure of election, anything else, then they do have to have legislation.
And so for cities that have annexed, they would be able to redraw the boundary based on new annexed territory themselves, or that's where they have to come back to us?
They can. So if they've got the resources to do that, I would expect for most cities, unless they've done some significant annexation from the time they had to turn in their last boundary update to the Census Bureau, that the census geography should be pretty accurate right now for the majority of cities, hopefully, and their count should be hopefully pretty accurate, unless I want to say sometime in 2019, maybe in the spring of 2019 was the last time they were going to update the BAS before the new geography was defined for city lines, county lines, and things like that. So that would have been the last cutoff. So it'd be from since that point, maybe spring of 2019 to now, if they've done a lot of annexation, then that may not be reflected.
Okay, thank you.
Okay, I think we have a little contribution to the discussion from Stuart.
So just taking a quick look at OCGA 3636-3, and this is the reporting requirement in the state law for an annexation that the city carries out. So I'm not seeing anything in here that makes it apply to a legislative annexation. But it does require that the city shall file a report with the Department of Community Affairs and with the county governing authority after an annexation, at a minimum, not more than 30 days following the last day of the quarter in which the annexation became effective, but it can do so more frequently. And part of that report, in addition to listing the property and the legal authority the property is being annexed by, it actually does also apply. It actually does also apply to General Assembly annexations. So the city is obligated to also report any legislative annexation as well. And part of this report is a letter from the governing authority of the city stating its intent to add the annexed areas to the maps provided by the Census Bureau during the next regularly scheduled boundary and annexation survey of the municipality, and stating that the survey and maps will be completed as instructed and returned to the Census Bureau. Then DCA is not supposed to add the annexation to any state maps until it is confirmed receipt of this report. Department of Community Affairs shall not provide certification of the annexation to the Census Bureau unless the governing authority of the city has filed a complete report as required above. However, compliance with the requirements of this code section shall be construed to be merely ancillary to and not an integral part of the annexation procedure, such that any annexation shall, if otherwise authorized by law, become effective, even though required filings under this code section are temporarily delayed. I believe that de-annexation would fall under this same provision because this is in the general procedures article of chapter 36.
But we have to promise that we'll do it just at the earliest opportunity.
Right.
Yes, sir.
That your intent is to do it.
Okay, thank you. And recognize Tom Gale to make a point.
I just wanted to point out, Stuart's on point as usual. But I do want to remind the committee, our friends over at the Department of Community Affairs have a specific recommendation for you all to consider, and that is that the cities have to send to them a shape file. I'm not a GIS expert, but a shape file that they use in working with the BAS. And they acknowledge in their recommendation to you all that some of the smaller municipalities may not have the resources, but their recommendation is for an adjustment to the DCA budget for contracts with the regional commissions across the state, all of which have GIS systems analysts and whatever the terminology is, who can help create those shape files to help the DCA comply with the BAS.
Yes. Mr. Chairman, can I respond to that?
Yes, please.
And I would love if they were able to provide shape files. That would be a way that we could create at least a visual map of these annexations. If that was something that was required, and they could provide that with the description that they're submitting for legislative annexations, a shape file. GIS is what we do. That is what our software is, GIS. And we could take that shape file and at least create a visual. It may not follow any kind of census geography, but we would be able to at least produce an image with that file that would show you where that area is in relation to the current city boundaries and things like that. So that would be very useful.
Just to add, Mr. Chairman, I think that is a reasonable request, both of Gina and her office, but also of DCA, particularly since they acknowledge that some of the smaller cities, which may not have annexations as frequently as some of the more growing areas of the state, may need help from the regional commissions. And I think that's certainly reasonable.
Okay, thank you. And yeah, look, before Gina leaves and before we move on from this, Chairwoman Tankersley has asked Blake to kind of, in her absence, she wanted to be here today, but in her absence, to add to the conversation.
Yes, and I'll be very short. She has a conflict in her district, which is why she couldn't join us today, but she wanted me to make a couple of points. We prefer to use Gina's maps when we get local legislation for annexations, just for the verification that, it's them and not the local government. Not that we don't trust anybody else, but we prefer our office to put the map together. So if Gina would ever get that capability, we would really like that. But that being said, we have taken to just this session requiring maps for local legislation from the city or for the legislative sponsor, just so we can see what's happening. But that being said, we would prefer verification from Gina's office. And then the second thing is for local annexations that take place mostly outside of the legislature, we obviously don't always know what's going on. So, and that affects who has to sign the bill, especially in the metro area. And I think Madam Chair Oliver's seen that. Because, I think DeKalb, you have to have a majority of the DeKalb people sign. And in Atlanta, you have to have 2/3. And when there's an annexation into DeKalb County, say with Emory, we don't know who has to sign that local bill if it's done on the local level, and we don't get that map. So those are the 2 points that Madam Chair Tankersley wanted me to throw out. So that's it.
Can I respond, Mr. Chair?
Yes, please.
That would be another good reason why having the shape files, if they're sending the map and they're able to provide a shape file when they do that, that way we would be able to overlay that onto a House district map and tell you if it does reach in, if this annexation does reach into a new House district or a Senate district. So you would know, we would have a visual to be able to verify that for signing off on local leg or other things if we had those shape files for that.
Thank you. And as Tom alluded to, and as we're discussing here, I had requested of DCA to provide us with a list of items that that may be policy and procedure for them, but may serve better being put into code. And that is attached to the packet that the committee members have. And Blake, I'd like to, if we could, if you provide that to Gina's department, also to look over and see if there's additional things that could be considered from that standpoint. So that would help us out.
I'd be glad to do that. Thank you.
Any other questions, comments? Okay, we'll move on to the last segment of our agenda, and I'll kind of want to preface this a little bit. We're going to talk a little bit about de-annexation, and as you, as everybody has kind of, or at least I have taken from discussions we've had so far this morning, this is a very, very deep subject that we're going to do just a quick overview on and kind of hold this over for later discussion. The primary focus of our study committee from an annexation standpoint is the policies and procedures around de-annexation, which kind of gets into a lot, or not de-annexation, annexation dispute resolution. I'm getting my words confused. So we are going to touch on de-annexation a little bit, and I'll ask, at this point, I'll ask Todd Edwards with ACCG to come forward to the microphone, and we'll begin that discussion. And again, understanding that this is a subject that will be possibly discussed later in governmental affairs or somewhere.
Thank you, Mr. Chairman, members of the committee. Again, I'm Todd Edwards. I'm the Deputy Legislative Director for ACCG. It is complex. I'm going to try to be as brief as possible, especially considering that I'm standing between y'all and a lunch. In summary, I'm going to try to point out in ACCG's policy position is that we believe that de-annexation and annexation should mirror one another. The processes, the procedures, the safeguards. And I'm going to try to go over that today, answer some of the questions that have already been asked, and also address some of the safeguards that can be incorporated in the de-annexation process, should you change it, to protect some of the issue or to address some of the issues that we've heard before and some of the concerns. There's been a lot of discussion over the past decade in this committee and others about annexation, the creation of new cities, and now the annexation arbitration process. At the center of these debates, a lot of talk has been on which level of government serves individuals best, which one's more efficient, which may offer more favorable zoning or land use conditions for development purposes, greater self-determination, and which one is more responsive to the citizenry. We've also heard a lot about private property rights. In recent annexation discussions, this committee and others have heard that citizens seek to be annexed. Citizens don't go out shopping for them. Property owners have a right to petition a city for annexation without a county being able to block it. Annexations are the natural way cities accommodate landowners who want to be served by the local government that is closer to them. And annexation service requests are often from landowners seeking enhanced services, not those developers seeking higher density or land use. And also lastly, the Georgia annexation law is based on individual choice. Unfortunately, I would respectfully submit to you that city residents and property owners who wish to leave a city or de-annex do not enjoy these same rights. Under current state law, property owners cannot choose whether or not they can de-annex from a city. Ultimately, that decision is made by the city, regardless of whether the individual has been provided the services that they were promised, if they are delivered substantial services for the taxes they are paying. Perhaps the city has grown too large and unresponsive to that individual's needs, or perhaps they don't feel their property rights are being protected. In short, current law and de-annexation, I'm gonna explain this the best I can very quickly. A landowner has to petition a county to get approval via a resolution. That landowner then takes that resolution to the city government, and the city can choose whether or not to allow the de-annexation or not by passing an ordinance authorizing it, or they don't have to act, and therefore that de-annexation is effectively blocked by the city. Under our proposal, and there's legislation that mirrors what we are recommending. I know it's old. It didn't make it far out of this. It didn't make it out of the Senate, but with Senate Bill 110, I believe that was the 2007 session, it has a lot of the provisions that I'm going to address very briefly here. But under this proposal, the county would still have to approve via resolution a property owner's petition to de-annex, but the city would not be able to block it. So it mirrors what current law is. You know, if you're going to be annexed, you have to be approved by the city, but the county can't block it. That's current annexation law. We're just asking that de-annexation be the same, and that, yeah, you be approved by the county, but that the city can't block it. That's fair. That's reasonable. What this proposal does in the end, it ends the annexation, de-annexation double standard. It also incorporates many safeguards, and a lot of those you have talked about today. Under the proposal, and obviously this would have to be changed at the legislature's will, de-annexation would not be automatic. The county would have to carefully balance that choice with the interest of the greater community. How and why should they do this? Because they represent the entire community, balancing those interests both in the incorporated areas and the unincorporated areas. It was noted earlier that in testimony that cities do respond to legitimate county objections on annexations. I don't think there would be any reason for counties not to responsibly respond to this for de-annexation petitions. Again, use the same dispute resolution that we're talking about now that's in law for those wishing to de-annex. If the city can't block it, allow them to object under the same conditions that are in the current annexation arbitration process. The language in the bill would have to be changed. It's 36-104, because that refers at this time there was an old dispute resolution process. So all that would have to be removed. I'm just asking simply under these conditions, put in the same process for both annexation and de-annexation. Again, have them mirror one another. That's fair, that's reasonable, that's equitable. Prohibit unincorporated islands. Nobody wants those. You know, someone wants to de-annex and is not contiguous to the unincorporated areas. Let's prohibit that. That should not be allowed. Use the same law again and for de-annexation as it is for annexation. In current law, that's 1/8 of the boundary or 50 feet. Service delivery, prohibit, we would agree that prohibit a service delivery plans, a city's plans from being invalidated, otherwise negatively impacted by de-annexation. Water and sewer, we may hear that it may interfere with the city's ability to provide water or sewer services. That should not be allowed to happen. That did not happen under the proposal you're looking for. The city, if it's within their service delivery area, they continue the services, they continue collecting rates. Heck, now that these property owners are outside the incorporated area, they could double, perhaps even triple the rate of the water and sewer services they're providing, so long as it's reasonable. They can argue it's reasonable under state law. As far as stranded infrastructure or unusable infrastructure, if a city declares, and this was touched on earlier under annexation law, that one or more of its facilities, say it's a police, fire station, library, is unusable due to an annexation, require the county to reimburse that at fair market value. If the value cannot be agreed upon between the city and county, have it go to a special master and arbitrator. Again, same as exists for current annexation law. Effective tax dates, this comes more into play with the cities with independent school districts that you mentioned earlier. If the city is losing commercial property that pays a lot and taxes to the independent school system, I think it's only fair that the change of tax dates be delayed out for about 1.5 years, or say the December following the year of the annexation, to give that independent school system time to adjust. That's fair, that's reasonable. Also under proposal, you're going to want to prevent property owners from skipping back and forth between being annexed into a city and de-annexed. Nobody wants those games. Nobody wants that type of shopping going on. Once you're annexed, say prohibit de-annexation within 2 years. Once you're de-annexed, say prohibit applying for annexation for another 2 years. those safety provisions are in that bill. Bonded indebtedness, you may hear that this will greatly complicate the bonded indebtedness of those who may choose to exercise their rights and de-annex from a city. It was addressed earlier, but I can't stress this enough. That should not happen. Create a special tax district for those who have de-annexed. They de-annexed on their own choice, but they should not be free to paying the obligated bonds off on that property. It was mentioned earlier, each area holds their debt. Everyone remains liable to that debt. And again, if citizen chooses to leave, they should keep making the payments. They can do so under the creation of a special tax district so that they're liable to pay off that indebtedness until that bond is retired. Conclusion, we suggest making the process again for de-annexation and annexation the same, putting an end to the double standard. Individuals should not use their right to self-determination once their property has been incorporated. Citizens can decide which level form of government works best for them. In doing so, you'd be respecting their property rights and at the same time providing safeguards that you may hear on some concerns that may be addressed later, and ensure that individual interests, the city's interest, and the entire community's interests are respected. Answer two questions that were brought up earlier. You may may hear that there are not that many de-annexations. There are not. I would respectfully submit that this is because the city has the authority unilaterally to veto that annexation request. You may also hear that current law is fine. The General Assembly wants to de-annex something bad enough and the city don't allow it, then the General Assembly can de-annex it. I would submit that you may not want to be in that situation, just as you may not want to be with having to approve annexations if, in fact, as has been alleged, counties are able to block that annexation. Leave that at the local level. Give them the dispute resolution process. Have the processes mirror one another. That would be sound public policy in ACCG's opinion. I thank you for your time and consideration. I'm happy to answer any questions.
Okay, thank you. And we have a question from Chairwoman Taylor.
Thank you. Just a quick question, and it was right there at the end when you were talking about paying off the obligation debt. Would it be determined by population or by tax-based values, or if it's a new library that's in this area, or how do you determine that?
I'm not a bond attorney. I'll say that up front. We have those that are much smarter than I up there. What I would suggest is if it's a countywide, obviously obligation, or, everyone in the county pays for it. If it's something of the cities on the bonded indebtedness for some of their fire, sewer, water, with water or sewer, I guess it gets tied into their rate, so they don't lose that. But any other ones, you would have to create and work with people smarter than I are of creating that district and keep levying that millage on their property to retire that debt. As far as the specifics, there are some within the bill, but I think that would have to be worked out by folks smarter than I, Madam Chair.
Thank you.
Okay, any other questions on the part of the committee?
Again, thank you for your time.
Thank you. And at this point, we'll ask Tom to come back to the microphone.
Thank you. So again, I think I'm here as a counterpoint to my colleague Todd over at ACCG. But before he already articulated some of the real major issues between with the proposal to de-annex. But before I say that, I've said many times Molly, Blake, and of course Stuart are great resources. But with Gina in the room, Gina does a great job for you all and for our cities that choose to use them. So kudos to your staff. De-annexations from cities are very different than annexations. It's apples to oranges to say that they're should be treated the exact same way and under law. The basic fundamental issue here is that when a city has a de-annex, a property de-annex, that property is forever gone from the city. I do not know of any instance, and maybe this is something to do some research on, but I don't know of any instance in which a de-annexation has occurred where there was a special tax district created to pay off any debt. It's my understanding that those de-annexed property owners just walk away without any debt obligation and also without any tax obligation to the city because they're no longer in the city. to think that making de-annexations, a process making de-annexations easier would potentially destabilize the municipals and especially if you don't take care of the debt issue, the institutional framework credit scores for the municipal class would be wrecked. And I'd encourage you all not to even consider this proposal. And from a political standpoint, this would be something that would really cause some of these suburban and exurban border skirmishes to lead to an all-out war between city and county governments across the state. I would encourage the study committee to take a pragmatic approach and focus on the annexation arbitration process. I really think that if we increase the level of conversations between city and county leaders prior to annexations being voted on by a city council or prior to a county feeling like they have to object to an annexation, that's gonna, just that process, those process improvements alone, and you all have looked at them, will really minimize some of the friction that's in existence, not eliminate, but minimize some of the friction that's in existence, primarily in the suburbs and exurbs of Metro Atlanta and a few other urban areas. I'll be glad to try to answer any questions if there are any.
Any questions on the part of the committee?
Thank
Okay,
you, Mr. Chairman.
thank you.
members of the
And
committee.
just as a request, I'll recognize Todd one more time.
I would concur with my colleague Tom from the Municipal Association that we're not aware of any de-annexed areas, having to create a special district to pay out bonded indebtedness. I don't want to speak for him, but if he can correct me if I'm wrong, I haven't heard of that either. I think one, because there's so few de-annexations, the only reason we brought that up and put safeguards is because it's such a sensitive issue. And we do want that safeguard to be, in the bill, or we would recommend it be in the bill in case it became an issue later. And second, if the process that is recommended by the bill in front of you and that we would concur with is pretty much the 100% method. You would have to have signed petitions from each property owner wishing to be de-annexed. It's not the 60, 100%, not large tracts. It would just be individual landowners. So that's why the bonded indebtedness may not be that an issue. Again, we just tried to address being responsible individuals representing counties and all of the folks, that if that is a concern, there are means by which to address it. And that's why that language was recommended in the bill, if I'm not mistaken.
Okay, thank you very much. Members of the committee have anything to add before we conclude our meeting today? Well, I want to thank everyone who came out and participated today and participated online today. This was a very informative and very useful meeting for us. If we do have lunch provided today by our co-partners back here, ACCG and GMA, and we appreciate that and ask everyone who'd like to stick around for that. I'm assuming that that's probably, it's okay. And if there's nothing else, we'll stand adjourned.